Inspector Vilakazi.
Worship.
On record.
We back on record, Worship. Worship, I believe my colleague has went through the affidavit, Worship, and is satisfied. Can proceed.
Yes. Examine your arguments in closing. Yes, you may proceed.
Thank you, Your Worship. This is an application for bail. The applicants are facing Schedule 5 charges. And I want to emphasize Schedule 5, not 6. In terms of the CPA Act. The applicant have been given reasonable opportunity to adduce evidence which they believe will satisfy the Honorable Court that the interests of justice permit for their release by bail. That's all what is required from the applicants to satisfy this court that it is in the interest of justice for their release. I must point out, Your Worship, that the applicant are charged of 2 times kidnapping involving 2 kids, intimidation, trespassing, contravention of Section 120 in bracket 3 in bracket B of the Firearm Control Act. Failure to produce license for the firearm when so requested. Contravention of Section 20 in bracket 1 in bracket A of PSIRA. Discharge of firearm in build-up area, 2 times assault, pointing of a firearm, possession of unlicensed firearm, in bracket a rifle, possession of dangerous weapon, 2 pangas, in bracket, malicious damage to property, vehicle belonging to maternal family witness. Your Worship, this is an interesting case. As you can see, the media in this court. Senior police officers are in this court. You have various Department of Education are observing this matter. It is a case of public interest. I just want to draw your attention, Your Worship, that this must not make the court lose sight of the interplay between private law and criminal law. And supporting what I've just said, Your Worship, I will refer you to the matter of Mokoena versus the state. Let me try and give you a proper citation, Your Worship. Mokoena versus state in bracket R03 in stroke 19 and in bracket 2020 ZA MP MHC 3223 July 2020 at paragraph 1. Brookman AJ, as he was known at that time, stated the following: in this review, Tone is reminded never to lose sight of interplay between private and criminal law. The law is dynamic, and students have over the years, just like courts, sometimes struggle to keep that in mind. I'm trying to ask your worship to say there is a similarity in this matter. There is element of private law, there is element of criminal law, so it must be balanced. I've already said, your worship, that it is a typical case of interplay between private law and criminal law. For the following acts are applicable. And I want to bring your worship to say that there are other laws that are applicable in this case. Section 28 of the Constitution of the Republic of South Africa. It deals with the right of children. Section 20 and 21, read with Section 7 to 9 of Children Act 38 of 2005. Section 3 of the South African School Act 84 of 1996. These acts have a bearing in this matter. Your worship, you'll forgive me, I will slow down to allow the interpreter to write.
No problem.
I realize it looked like I'm increasing speed. Your worship, to understand the interplay of these laws, I would like to start to talk about third applicant or third accused. The state is opposed to granting of bail for the third applicant or accused. The refusal is based on the statement made by the investigating officer. I've already highlighted the charges, your worship. But one important charge, your worship, that I want to dwell a little bit on it, is the kidnapping, 2 times kidnapping. Your worship, it's common cause that that applicant or accused number 3 is the father, or let me put it correctly, the biological father of the alleged kidnapped children. And in terms of the law, he has a right a legal right to look after his children. That's what the law says. It's not me, your worship. It is the law. The law gives unmarried fathers the right to their children. The law makes it very simple, Your Worship. It says if the child is born when the mother and the father are staying together as man and wife, the father has a right to that child. That right doesn't end there, Your Worship. It goes with other responsibilities. The father is responsible for maintenance of those children, upbringing of those children, health of those children, schooling of those children. That's what the father is about. The law of this country promotes that. That's why we have this Children Act. That's why the Act makes it very clear who is the parent. Your Worship, I have just demonstrated a little bit that the charge of kidnapping has no basis. Keeping the said applicant in prison without a basis goes against first the public interest, secondly the rule of law, and lastly the interest of justice. People are using the law to do wrong things. Your Worship, the state has not put any documentary evidentiary proof that either the grandmother or any other person has been granted by family court or any other court that has jurisdiction, authority to take over the children from their father. One of the rights children have from their parents is protection. This right comes from generation to generation. Fathers protecting their children and their grandchildren. The rights of children, the best interest of children is with their parents and their family at large. Paternal family at large to the best. Your Worship, the applicants, let me put all of them, the state has failed to contradict their submission relating to the requirement of section 60 in bracket 4 in bracket A of the Criminal Procedure Act. The state has not alleged that there is likelihood that the third or the second or the first applicant, if released on bail, will endanger the safety of public or any particular person or will commit a Schedule 1 offense. In that way, I submit, Your Worship, that the submissions of third, second, and first applicant has not been contested. In fact, to the best, they have been confirmed by this state. Your Worship, the public is abused. Which public will turn against a person who has the rightful authority to look after his children? The state has not produced any documentary proof that the relevant children court or any court that has jurisdiction has removed the children from their father and granted to their grandmother or any other person. The state has not produced that evidence. And thus it cannot contradict this particular section 60, 4 in bracket, A in bracket. So that is not contested, Your Worship. I submit. I now go to section 60 in bracket 4 and bracket B. The state has not contested the submissions of the third, second, and first applicant, but it was playing into the public gallery, raising issues that are not relevant to this bail application. I will address it later. The state has not alleged that if the third applicant is released on bail, will attempt to evade his trial. Let me put it better in saying the state has not alleged that the third, second, and the first applicant will attempt to evade their trial. In reality, that has not been contested. That's the reality of the situation. In terms of section 60, four in bracket, D in bracket of the CPA, the state has not been able to contradict the submission of the first, third, second, first applicant. This relates to if the applicants are released on bail will undermine or jeopardize the objectives of a proper functioning of the criminal system, including the bail system in terms of Section 60, 4 in bracket, D in bracket of the CPA. Again, Your Worship, the submission made by the applicant has not been contested. So this particular section has been complied with. I now address you, Your Worship, in terms of Section 4 in bracket of the CPA. The state attempted to allege boldly that there is likelihood that the release of the third, second, and first applicant will disturb the public order or undermine the public peace or security. The allegation, Your Worship, is not substantiated. In fact, the state fails to contest their submission in terms of Section 4 in bracket, Section 16 bracket 4 in bracket E of CPA. The bold allegation by the state that the first and second applicant are a danger to community. It's not substantiated. Or the community being danger to the first applicant, it has no merit, Your Worship. It is something that the police is trying to put this court in a situation where it will be on doubt. Your Worship, in the last 2 weeks there has been a church in Katlehong, and the people of Katlehong have been supporting. And the people of Katlehong are not against the law. They know, and the police know, who is the father of the children. They know very well. They wrote in their own statement that the accused number 3 or the applicant 3 is the biological father of the 4 children. It's not me, Your Worship, is the police who said of the 4 children, and it is confirmed, yes, he has got 4 children. It is the police who have confirmed, Your Worship, that the third applicant or third accused was staying with the mother of the children in a hired room, confirming, Your Worship, what the law says. If a child is born between the man and the woman, not married, staying together, taking themselves as man and wife, the father has the responsibilities for those children. He's got the right, Your Worship. You can't charge the man for kidnapping his own children when he had the right given by law, except if you produce evidence that the law has removed that right. Only the law. Only the law can remove that right, that parental right of the third applicant. Your Worship, I have displayed to you that the allegation that the community is in danger, it has no substance. It has no basis. In fact, Your Worship, the church is just behind the police station. It could take to the west less than 3 minutes to reach the church. But because they are playing into public gallery, they want everybody to see the best accused to be so bad in community, and they come up with all these allegations. In fact, it looked like it has political connotation, Your Worship. Because how could a man charged for protecting his own children, looking after his children, looking after the education of his children? Your Worship, I have not even mentioned the issue of the fact that the father took the children to school, and he has a right to take them back home. So if he fought for his children, being denied his children using the SAPS. That's the reality of the situation, and not all what is going to be displayed that the pastor just went to school. Your Worship, if you get a call that your daughter is being attacked, I can assure you this hearing will be postponed for you to address that, because it comes inside you. The motherly and fatherly comes up, and the best accused is being told that his child is being attacked for his grandchildren. Can he stay? That will be addressed at the trial, Your Worship. I don't want to go in there. And I've said, when they raise these issues of issues that are not supposed to be in this court, and I did stand up and said that issue is for trial, and they continued with it. Your Worship, the public needs to know the truth, and the truth shall set them free. And in this situation, I believe that Your Worship, it has been brought to my attention that on the 5th of September, the issue of children will be dealt by a court that has jurisdiction. And I don't understand why should the father be charged for kidnapping. That's the worst situation. kidnapping is a serious offense. Purely because the police are trained enough, they know the law, they know the rights of parents, they know what is supposed to come to them before they act. And they acted without all that information. And that's the situation, Your Worship. Let me, Your Worship, just show you common cause issues. Both parties, the state and defense, agree that the third applicant is the biological father of the children alleged kidnapped. The first applicant is the biological grandfather of the two children alleged kidnapped. And it's common cause, Your Worship, that the third applicant is the son of the first applicant. It is common cause, Your Worship, that the third applicant and the mother of the children were staying together as man and wife, having equal responsibilities. You know, this country, the constitution of this country brought great things, more specifically for women. Before this constitution, women were down there, and this constitution gave them the 50-50 position. And that is reflected in the Children's Act. More importantly, the children, whether born in marriage or out of wedlock, have equal rights. This didn't happen prior to the Constitution. These rights, Your Worship, cannot be taken by anybody except the court that has jurisdiction to do so. Not even police can take it. They cannot abuse the law because they are policemen and just go and arrest a father of a child on a serious allegation of kidnapping. That's an international problem of kidnapping children. It's an international problem. So you cannot just plug it anywhere where you think it will suit. It is common cause, Your Worship, that the father took the children to school as required by law, that every child has a right to education, and the child below the age of 17, the parents must make sure that the child go to school and account for that child. The father is here, the children can't go to school because they lack that protection. Their father is their protection. It's common cause that these children are not well, Your Worship. The state, in its own affidavit, it alleges that they've got chronic, and that's true, Your Worship. That's the position of the children. They need their father. They need their grandfather. That's the position, Your Worship. Now I have alluded, Your Worship, that there are law applicable parental responsibility and right of unmarried fathers. Section 21. Section 20 deals with married fathers, give them their right. Section 21, 1 in bracket, of the Children Act 88 of 2005 gives full parental responsibilities and right in respect of the third applicant or third accused, and thus a charge of kidnapping is scandalous, vexatious, and irrelevant. The Act, Your Worship, provide a mechanism when the two parents have dispute about the child. Thus we submit, Your Worship, that dispute can only be between the mother and the father when they are all authorized guardian or parents in that fashion. If he has authority from court that he is looking after the interest of that child. The court must first grant a person custody of the children before the person can claim to have authority on the child or children. You can only do that when you have been granted custody by the court with jurisdiction to do so. Not policemen. The policemen do not have that power to grant anybody authority to take over the child belonging to his father or mother. So the state has failed to come up with a clear position showing that children were lawfully removed from their father. I've not seen anything. There is no allegation, not even a hearsay, Your Worship. At least there is a hearsay on other issues, but there is no hearsay to say the grandmother, maternal grandmother, has authority to remove these children from their father. The state confirmed, Your Worship, that the mother and the father, the third applicant, were staying together. That's the state, not me, Your Worship. It is the state confirming that. And they fail to produce evidence or allege that the mother will produce authority on trial showing that he was granted custody of the children. The removal of children from their parents can only, and I repeat, can only be done by the intervention of social workers, family advocate, social services professionals, or other suitable qualified person, and lastly, court with jurisdiction to deal with such matters. Now, those other people will have put recommendation to the court to deal with that situation, to remove for good reason, not just because the mother of the children has passed on, so anybody can just have access to those children. Doesn't work like that. Whether customary or in a civil society, it's worse in our constitutional democracy, because the law is clear about children. I have already alluded, Your Worship, that in terms of Section 3 of the South African School Act 84 of 1996, the third applicant is required by law that he must cause his children to attend school. That he cannot do locked up. This means taking them to school and picking them from school. In this way, my Lord, my worship, the charge of trespassing is against scandalous, vexatious, and irrelevant, because he is required by law to take the children to school and to pick them up at school. Your Worship, I've already alluded that any parent, no matter the child is smoking nyaupe or do anything, drugs, but if it's your child and you hear that it's being attacked, you will jump. You will even forget that the child is under the influence of nyaupe, because it's a parent. It is, you're born with it. It is there. I once saw one of the TV interviewing an old man sitting there with his child being beaten because he's smoking nyaupe. And when he asks, how do you feel? He says, I don't agree with what my child is doing. But it's my child. There is no way I can denounce him to be not my child. And that's the issues, Your Worship. You'll realize that as soon as accused number one is told that his child is being attacked, he has to go there. Your Worship, it is very interesting, and perhaps this will come up in trial, where the education will explain how did they come to the conclusion to deny a father his child. And in fact, they're supposed to be protecting those children and know who's the parent of the child, who's the father and the mother of that child. In my experience, Your Worship, whenever I go for my grandchild at school, the school teachers and principal will ask me, where is the father or mother of the child. And this is done effectively every time I go there. In this case, I do not understand, Your Worship. Perhaps the state will give us a clue on that. How do they prevent the father to take his own child? On what basis did they do that? Perhaps, Your Worship, some people have connection at the school that says deny the biological father of the child from taking his child home. Your Worship, the whole issue of this centers around the two children. Whatever we're talking about centers around the two children. And the question of what the state is alleging, danger to the community. Which community is in danger? Because if that school doesn't want those children, the father has the responsibility to look for another school to take his children to that school. So what danger are the applicant posing, specifically the third and the first applicant posing to the community? That position has no basis, Your Worship. It is just playing politics in court. Or they act on some instruction from above that makes sure that the first accused is not getting paid. Not because the law says so, not because there are tangible reasons that can be given that will make the first, second, and third applicant not to be granted pay. My Lord, let me refer, Your Worship, let me refer you to the case of State versus Diale and another. At paragraph 14, Kubushe J states the following: a court cannot find that the refusal of bail is in the interest of justice merely because there is a risk of possibility that one or more of the consequences mentioned in section 4 will result. The court must not grope in the dark and speculate. A finding on the probabilities must be made unless it can be found that one or more of the consequences will probably occur. Detention of the accused is not the interest of justice. And the accused should be released. This is a typical case of where the accused are kept in prison not in the interest of justice. Your Worship, let me refer to another case. In the matter of Senwedi, if I pronounce it properly, it's Senwedi versus State. The highest court of the land, Constitutional Court, at paragraph 27 stated the following: with regard to a person's right to freedom, our courts must defend and uphold the Constitution and the right entrenched in it. One of the most important rights from a historical perspective is unquestionable deprivation of individual individual's liability. Liberty, not liability. Liberty. This court said in Pereira that C, in bracket C, conceptual individual freedom is a core right in the panoply of human rights. And I'm aware that the human rights people are here. They may understand that these rights are protected. The apartheid regime repulsively and capriciously deprived people of their freedom under illegitimate legislation. I'm a victim of that, Your Worship. That paid no respect to the right to freedom and security of the person. We are therefore constrained to jealously guard the liberty of person under our Constitution, particularly in terms of Section 12 of the Bill of Rights. Your Worship, we need to protect this right. It's a right that only when the state show beyond doubt that the person has committed something that may disrupt the administration of justice. Your Worship, I refer you to the matter of DJVB, D.J.V.B, and another vices the state. My favorite Judge M.F. Lekhodi states the following: bail conditions have always served to ensure that whatever fear the state might have in the release of the accused person is taken care of. It is necessary consideration as also envisaged in Section 60 in bracket 6, which provide that in considering whether the ground in subsection 4b bracket has been established, the court may, where applicable, take into account binding effect and enforceability of bail condition which may be imposed and easy which such condition could be breached. Your Worship, I have dealt with the situation more importantly of the third applicant. Without the third applicant in picture, the rest wouldn't be before you. Before people take me wrong, Your Worship, the man and the women in blue uniform, they do a good job. But sometimes you have those that tend to focus on other issues. And therefore, we respect the men and the women in blue uniform. They do a good job. They make sure that we are safe. And when I'm dealing with this issue, it should not be as if I'm criticizing the police. That's not the case. Your Worship, the prosecution is not a rubber stamp for police. They are not a rubber stamp. When the police want somebody to remain in prison, they should not expect prosecution to just rubber stamp what they want. No, the court is not their rubber stamp. The prosecution and the court are independent of anybody, and they administer fair, equitable justice. There are few issues that I want to address Your Worship, about the second applicant. The police have confirmed that they've gone to the address he gave them as his home, and they have confirmed that he is not staying there in that address he frequently visited. It's not new with the accused for a person who works somewhere else. It has been done since the white men came into this country. We have been staying in the compound, hostels, and go home once a year. So it cannot be an issue that the accused, the second applicant, goes home once or it does not stay there frequently. It's not an issue, Your Worship. It is there. It is normal to African people. It is daily. It won't stop now. No democracy has failed to stop it. You have people moving from the rural areas all over to stay in the squatter camps. It's not their own making. It is the situation they are faced with. The accused, or the second applicant, he has demonstrated in his affidavit that he stays at the employer's property. There is nothing unlawful about that. In fact, the state, when I say the state, Your Worship, please forgive me, I do not refer specifically to the prosecutor. I'm referring to the police. The state has confirmed in their hearsay evidence that the second applicant was arrested at the police station. He was not on the run, Your Worship. He was not any other place. He was arrested at the police station. So what danger, if he can't go take himself to the police station, what right do they have to even try to allege that he is a security risk and a danger to the community? That won't stand, Your Worship. Then they come up with the allegation that his ID, they didn't have the ID document. It's the work of the police to go and get the ID document where he stays. And they have not done that. So they cannot put a blame on the second applicant. In fact, the ID number is mentioned in his affidavit. So that in itself, it has been taken care of. The state wants to focus more on flight risk. All the applicants have stated that they do not have families outside the Republic of South Africa. They have already stated again to say that they have no intention to evade coming to court. And that has not been contested, Your Worship. Has not been contradicted. There is no single clue that shows that they are a risk. I've already argued, Your Worship, that in terms of section 60 in bracket 4 from A to E, that the state has not contested all those issues. And the second applicant, Your Worship, there is nothing in law that makes him to be denied bail. Nothing, Your Worship. I now want to dwell on the first applicant, the target that the police have. In actual fact, 2 and 3 suffer because of accused or first applicant. Perhaps that's why we see changing of prosecutors as a sign that perhaps the other prosecutor does not agree with what the police are asking him to do.
Your Worship,
Yes.
my apologies, Your Worship, but such innuendos are unacceptable, Your Worship. How
Yes.
does he know all of that?
Wicked, I mean, I feel like you're attacking.
I mean, that's unacceptable.
Your Worship, I will withdraw that.
Yes, please.
Right. The first applicant, a known pastor, more popular throughout the country, born and bred up in Cutler Home. There's no question about that. It's common cause and common knowledge. I want to address first the issue of 9 charges withdrawn. Perhaps, Your Worship, it's my lack of understanding or interpretation of the word withdrawn. If my understanding, the state only withdraw a case when it has not gathered sufficient evidence take the person to court, perhaps successfully. That's the issue. My understanding that I do not think that until that matter is brought back to court, the person must tell the court that I've got 9 or 7 or 1 withdrawn case. That's not what the law requires. The law requires previous convictions, outstanding charges, and not withdrawn cases. They are neither there they do not assist the court to come to the right conclusion. The investigating officer tell this court that some of those charges are being investigated and may be reinstated. But it doesn't say when were those charges leveled against the first applicant. When were they withdrawn? It could be 30 years, 40 years, 50 years, or a year, or 6 months, or 2 days ago. We don't know. The court cannot work on speculation. Does those charges contribute towards granting or refusal of bail? Your Worship, I submit that they are not relevant. It's just an effort to try and dent the image of the first applicant. Your Worship, I am of a belief that the court should consider each case on its own merits. There should be no impression created that the prosecutor is just a rubber stamp of the police as regarding whether granting of bail or not, and as well as the amount of bail to be paid by the applicant. In conclusion, Your Worship, I have demonstrated to Your Worship that there is nothing in law placed before this honorable court that will make this court not to grant the bail. I have demonstrated to you, to the court, that the continuous detention of the accused or the applicant is against the interest of justice. Your Worship, can I approach?
Yes, you may.
Thank you, Your Worship. Oh, by the way, I said in conclusion.
Yes.
Let me conclude, not to start afresh. Your Worship, this is the case of the applicant, and if there is any other issues that Your Worship wants me to address, I'll be able to do so, or to clarify. I'll be able to do so, and I know as an old man I take my own time, and even thinking comes later. I think, Your Worship, I will stop here and allow my... Thank you.
Thank you. Yes, Mr. Vilakazi.
As to the court.
Sorry, before that, Mr. Poyen, you want to interpret this one first or combined? Let's give Mr. Poyen to translate for the applicants.
Ke sona se nya aska lo sa pa pa no ba tuna di se e ko se na ke se ke ka ba se ke 6 le hape wa lo sa no ba dinga le la te le se ba le le ko sa no la ko ta la molao le o ke ya pa ba ba di di se tsa so a se tunya o sna di to mane go tsa license tunya se tunya o pela se tshabo ko se le te tsemba su pa mtuka se tunya o tsara di thala ko tsa so se kutsi tshwantsi ba motho le hape ke tsona e ditlhatse ya ntlhabusa mabapi le molato e le shebane le ona a ba hlalosa gore molato ona o shebuwe ke naha ka bophara le hape na le department tse fapaneng tse tlileng go ba sekolo ba ke ba tlhansi se wa hlalosa gore go kopa le kgotlale ele thoko mabapi ya melawana e tla se buiswang go melawana ya private le melawana ya criminal ba le kgotla e shebisitse hantle ka melao ena e tla sebetswa kgotsa e tla sekwa ka melawana e mengata e tla tshwanela go latela a ba kenella ya gore mabapi a moqosi wa boraro wa hlalosa gore mosepisi o kgatlanong le pedi mabapi a se se kotseng ke leponisa le le etsang dipatlisiso kgotsa se a se kwetseng mo lekwalong la boikanyo wa tlhalosa gore molato o tlhosang ona kgotsa molato o motlhosiwang wa boraro a o tlhosang ona wa okhipepa a o tlhaloganye gobane wa tsebagala pela le go tla gore yena motlhosi wa boraro ke yena ntate wa bana ba ba kilediweng se tlhalosa gore ya ka molao ke yena a nang le tokelo ya go tlhokomela bana a ba ise sekolong a ba latele sekolong a sekolo setswa le gape ile wa bua kgotsa wa tlhalosa mo na le gotleng gore bana ne ba dila mmogo le mma bona le ntata bona ntse ba sa nyala se se tlhalosa gore ntate le yena o na le tokelo ya go tlhokomela bana tokelo eo e tsamaya le maikarabelo a o netefatsa gore wa ba godisa bana ba isa sekolong le gape wa ba fepa le ke ka gore a sa tlhaloganye ba neng motlhosi wa boraro a tloswa molato wa go kidnapa bana ba ba tsalang ba gae ba madi le gape wa tlhalosa gore ga gona bopaki bo bo tlisitsweng go bontsha gore go ne gwa ba le lekgotla le le nang mokela ditokelo la gore a dule le bana kgotsa a ba tlhokomela ke ka gore yena a sa tlhaloganye molato o ba mo tlosang ona wa go kidnapa bana a ba tlhalosa gore ba mmuso kgotsa mosekisi o tlholeile go bontsha ka bopaki le ba botlalo gore go ka etsagala gore batlhosiwa fa ba ka lokololwa ba tla ba leya kgotsa ba sa tlhaela pela go tla fa ba ka lokolola ka pedi le gape wa tlhalosa gore ga gona tokomane kgotsa lekwalo le kwetsweng pela lekgotla le le tlhalosang gore ntate kgotsa motlhosi wa boraro a sana ditokelo tsa gore a ka dula le bana kgotsa a tlhokomele bana ba gae empa dintlha tsotlhe tse di buang ke mosekisi ga ona mo di kenang teng mo molakeng ona o sekwang kgotsa o romanyetseng pela lekgotla le gape ba tlholeile ba mmuso kgotsa mosekisi o bontsha ka bopaki le ka dintlha gore tlhosiwa fa ba ka lokola ka pedi ba tla ba leya ba sa tlhaele pela lekgotla morago ba lokolle ka pedi le gape e na le phoso e tshosang haholo ya gore tlhosiwa fa ba ka lokolwa e tla ba batho ba leng kotsi setšhabeng le gape ga ona bopaki bo bo tlisitsweng ke ba mmuso go bontsha gore batho ga ba dulelwa mo setšhabeng kgotsa bangwe ba setšhaba ba ka nna kotsing fa ba tlhosiwa ba ka lokolwa empa ba etsa mohlala a bontsha gore kereke ya bokatlego e na le dilo tse pedi se utsu se se bontsha gore batho ba setšhaba sa katlego ba sa tota batlhosiwa ba ba arogopela le gape le maponisa ba tseba gantle gore motlhosiwa wa boraro ke ena ntate wa bana ba ba kilekiweng kgotsa ke ena ntate o ba tsala le ge wa tlhalosa gore ya ka molawana wa yona naga ena ya rona ya Aforika Borwa wa tlhalosa gore fa mme le ntate ba dula mmogo o sa ile tlhoko gore ba nyetswe se tlhalosa gore ntate le mme ba na le maikarabelo kgotsa ditokelo tse lekanang tsa go tlhokomela bana se tlhalosa gore ena ga a tlhaloganye gobaneng motlhosi wa boraro a tlhosa molato wa go kidnapa bana ba e leng ba gae ba ba tselang empa wa tlhalosa gore lebaka le letsang gore ba etse dintlha tsena kaofela ke gore ba le shebisise lona mo setšhabeng jaaka batho ba ba repela matlho a setšhaba a ba tswela pele gore yena ntate o na le tokelo ya go tshwara kgotsa ya go tlhokomela bana a ba ise sekolong a ba late sekolong le gape ba etsa leano ka seemo kgotsa bophelo ba moatlhodi gore yena a nang ka etsa jwang fa ka utlwa gore moradi kgotsa mora wa gae o mathata o tla netefatsa gore buisano kgotsa ona wa molato ona wa ema gobane ke ena mosebetsi wa gae jaaka motswadi wa ngwana a na etsa leano go bontsha gore ke seno sa etsa ke motlhosiwa wa boraro kgotsa motlhosiwa wa ntlha moraga gore a utlwe gore mora wa gae wa tlhaselwa setšhabeng ke ka moo ge yena o ile a tswa a ya ko ketsagalong eo a ba tswela pele gore a tlhalosa gore motlhosiwa wa ntlha ke ntate wa motlhosiwa wa boraro se se tlhalosa gore ke ena ntate mogodi le a kana tlhalosa a kena a re mme le ntate wa bana ba dula mmogo se se tlhalosa gore ba aroganya maikarabelo a go dula le bana kgotsa go busa bana yaka ba tlhalosa gore molaotheo wa naga ena o fetogile se se tlhalosa gore basadi sa ba na le ditokelo tse di lekanang le tsa banna le gape ga ona motho a nkela motho o mongwe tokello e a finyellwa ke molaotheo hantle le court kgotsa tsamaiso ya toka ke yona fela na le maatla a ho nka tokello tsa motswadi a ba tswela pele a hlalosa mabapi a seemo sa bana se se hlalosa a na hlalosa a dumela a netefatsa hore ka nnete bana ba ja ditlhare kgotsa ba nwa meriana e hlayang bakeng ya sekgowa se hlalosa hore ba hloka tlhokomelo ya ntata bona ya ntatemoholo wa bona le hape a hlalosa hore ntse sa ikutlwisiswe hobane a ntse a dumelane le molato o mong wa ho qosa ona wa ho kidnappa hobane yena moqosi wa boraro ke yena ntate ya tsalang bana ba babedi a ba hlalosa hore motho o tshwanetse a fumane tokello kgotsa lekwalo le hlayang lekgotla pele ga ka bana a dumele bona se se hlalosa hore a se maponisa a na le matla ao netefatsa kgotsa ao ka qeaqea gore bana ba tshwanetse ba dule le mang ba tshwanela ba le mang empa ke lekgotla fela le nna le matla ao etsa qeto eo a ba hlalosa a tswela pele mabaping a seemo sa moqosi wa bobedi a ba hlalosa gore maponisa ka nnete a ile a tsamaya netefatsa address mo a dulang teng le hape ba fumana gore moqosi wa bobedi a dule moo addresseng eo ka dinako tsohle hobane o la hlalosa gore yena o dula le motho ya mo sebeletsang le moqosi wa ntlha le hape o tlwaelehile hore batho ba dule mafelong a fapaneng ho ya ka seemo sa bophelo ba bona ke ha nngwe na sa bone bothata o se o moqosuwa wa bobedi a dule ko addresseng le motho a mo sebeletsang le hape a ba hlalosa hore ka nnete maponisa a mo fumane ko police station se hlalosa hore yena a na sena maikemisetso ao baleya ke ka hore he o sena bopaki ba gore fa ka lokollwa o tla baleya kgotsa sa hlaya pela lekgotla la molao hobane maponisa a mo fumane ngwana mo ko police station a ba hlalosa a ifeleletsa mabapi a baqosi ba bangwe gore a gona bopaki bo tlisitsweng bo bontshang gore baqosi fa ba ka lokollwa ba tla baleya le hape mabapi a dintlha tse hlano tse lekgotla le tshwanetse le dipontshe kgotsa le shebisise pela gale ka dumela kgotsa le ganetse kopo ya tokollo ya pele ya baqosiwa a hona bopaki bo tlisitsweng gore baqosiwa ba ka se latele melao ba ka se thusetse bapaki kgotsa ba ka se pate bopaki bo tla sebediswang ho seka ke tsona tse dingwe tsa dintlha tse hlano tse di shebisiswang le mabaping a melato e robong e leng ya qoswa moqosuwa wa ntlha wa hlalosa gore ha hona molao o ileng wa hlalosa gore moqosuwa o hlahelang pela lekgotla o tshwanetse a hlalosetse lekgotla mabapi a melato e ileng ya qhala lekgotla empa le tla batla ho tseba gore na moqosuwa o na le katlholo tsa kgale kgotsa o na le melato e meng e a tshwanetseng a e tsamaele pela lekgotla wa hlalosa gore melato e qhadilweng ha hona mo e kenang teng le hape mosepisi o la botsa kgotsa a bua ka yona melato e qhadilweng e robong maikemisetso a hae e na le ho senya dipina mo setjhabeng ka dintlha tseo kaofela di bopaki bo tlisitsweng wa hlalosa gore ha gona molao le o thibelang gore baqosuwa ba lokolle ka pele di ka dintlha tsohle tse a di tlisitseng o bontshitse gore tsamaiso ya toka e dumela tokelo ya baqosuwa ba le bararo gore ba tswele ka montle ba lokolle mo ditjhankaneng ho fihlela ba le ba fetsa ho seka molato wa bona empa fa ba ka tswela pele ba dule ditjhankaneng tla be ona kgethollo mo ditokelong tsa bona tsa sa molao Thank
you. Mr. Vilagadi?
As it is, of course. Yoshi, before I approach, I wish to just explain how my submissions, the sequence of my submissions, Yoshi. I first plan to give a brief detail or exposition of the applicable laws in relation to bail applications, and then I move on to a brief explanation of the facts. By the facts I mean what led to accused 1, 2 and 3 to be here. on the 5th of August 2024. And then I attempt to apply the laws and the principles outlined to the facts to try and show this court that accused 1, 2, and 3 should not get bail, are not eligible for bail. Beginning with the exposition of the law, Your Worship, the starting point in every bail application is section 35, subsection 1, paragraph F of the Constitution, which states that everyone who is arrested for allegedly committing an offense has the right to be released from detention if the interest of justice permits, subject to reasonable conditions. This section of the Constitution is given statutory effect in Chapter 9 of the Criminal Procedure Act 51 of 1977. Thus, Section 60, subsection 1, paragraph A of Chapter 9 of the Criminal Procedure Act 51 of 1977 states that an accused person in custody in respect of an offense shall be entitled to be released on bail at any stage preceding his conviction in respect of such offense, unless the court finds that it is in the interest of justice that he or she be detained in custody. Therefore, from the above, it appears clearly that the power to grant or refuse bail is essentially a judicial one, and that the court will lean in favor of liberty and grant bail where possible, provided the interest of justice will not be prejudiced by this. Put simply, bail may not be refused unless there are sufficient grounds for believing that the accused will fail to observe the conditions of his bail. Section 60, subsection 4 of the Criminal Procedure Act provides that it will not be in the interest of justice to release an accused person on bail where one or more of the grounds listed in paragraphs A to E are present. Such grounds include A, where there is a likelihood that if released on bail, the accused will endanger the safety of the public or any particular person, or will commit a Schedule 1 offense, or where there is the likelihood that the accused, if he or she were released on bail, will attempt to evade his trial, or where there is a likelihood that the accused, if he or she is released on bail, will attempt to influence or intimidate witnesses, or to conceal or destroy evidence, or this is D, the preceding one was C, this one is D, the subsequent one, where there is the likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. And lastly, E, where in exceptional circumstances there is the likelihood that the release of the accused will disturb the public order or undermine the public peace and security. Now, Your Worship, the state submits that in this current application for bail before this honorable court, there are several factors which indicate that almost all the grounds listed from paragraph A to E above are present, and therefore it would not be in the interest of justice for any of the accused persons to be granted bail. Bishop, for convenience, I wish to refer to them as accused persons. I understand the applicants, Your Worship. I don't want to confuse myself. Okay, and then moving on to the next point in law. As it is common cause between the state and the defense that this is a Schedule 5 application for bail, Section 60, subsection 11, paragraph B, shifts the burden of proof in that the point of departure, owing to the charge or charges preferred against the accused, is that it will not be in the interest of justice for any accused persons to be granted bail unless such accused person can show that, or rather can show by way of evidence to the court that his release on bail will not undermine the interest of justice. Thus, evidence must be produced by all accused persons that if released on bail, it is unlikely that they will endanger the safety of the public or any particular person, or commit a Schedule 1 offense, or attempt to evade their trial, or rather not even or and attempt to influence, or rather, let me just start again. The first one, it is unlikely that they will endanger the safety of the public or any particular person, and it is unlikely that they will attempt to evade their trial, and it is unlikely that they will attempt to influence or intimidate witnesses, or to conceal or destroy evidence, and it is unlikely that if released on bail, they will jeopardize the proper functioning of the criminal justice system, including the bail system. And lastly, it is unlikely that their release will disturb the public order or undermine the public peace and security. The state submits that no sufficient evidence was led by any of the accused persons which can lead this honorable court to the conclusion that none of the sections, or rather none of the section 60 subsection 4 paragraph A to E considerations are likely to materialize should the accused person be granted bail. Now, moving on to the facts of the case, Your Worship. As we all know that there's video footage circulating in social media everywhere, be it Twitter, WhatsApp, Facebook, where it is shown that accused number 1, accused number 2, accused number 3 entered a primary school in the township of Katlehong, wherein accused number 1 was wielding machetes, 2 machetes or pangas. Accused number 2 is believed or is seen there with a rifle, what may be perceived or understood to be an AK-47. Accused number 3 is seen dragging 2 kids out of an office building in the premises. Now, firstly, in the state's affidavit, it's indicated that there were 2, there's video footage, there's another video footage which may not have gained such popularity as the first one, but then there's a video footage, the state is in possession of a video footage showing that accused number 1 also had another rifle in his boot. Took out that other rifle. He is seen discharging that rifle to disperse people who were in public, or rather in the streets, so that he can drive and leave the crime scene. Now, Your Worship, that place where they were is a primary school. Kids there, Your Worship, just to put things into perspective, some of the kids there a few months ago were in nursery school crash, Your Worship. And it is seen that accused 1, 2, and 3 were carrying AK-47 in front of crash kids who were in crash a few months ago. Just last year ago they were in crash. Some of these kids have never seen a gun before. Some of these kids have never seen a machete before. But the video footage that is circulating indicates that they were exposed to that by accused 1, 2, and 3. Now, in applying the facts, Your Worship, in applying the law to that short piece of fact, Your Worship, section 4A, the question which needs to be asked as to whether it would be in the interest of justice for accused person to be released on bail is there a likelihood that if released on bail, accused persons will endanger the safety of the public or any particular person or commit a share of one offense. Now, the evidence before, or rather, which the state has, indicates that accused 1, 2, and 3 have no permit, have no license to carry rifles, Your Worship. These are wartime weapons. They carried wartime weapons at a primary school, Your Worship. Now, one rifle was taken, or rather located, and was taken away from the accused persons. The other one, which was in the boot, has not been located by the police. It's still with accused 1, 2, and 3. So meaning they are still in possession of an unlicensed firearm, which is concealed somewhere. I don't know where, because we don't know where accused number 1 lives, judging by his multiple premises that he gives. So, Your Worship, the question that the court needs to ask itself is, will release or on bail of accused 1, 2, and 3, will it not endanger the safety of the public, Your Worship? These are people who have the brazen audacity to go to a primary school with guns, rifles, AK-47s, and expose kids to AK-47s. And there's another gun that's still circulating amongst them that hasn't been located. If the court releases accused 1, 2, and 3, and they have, and furthermore, Your Worship, this also has to be emphasized. They are not skilled to be carrying AK-47s. They have no permit. They have no license. They never went to training to carry AK-47s, and yet they went to a primary school unskilled to carry AK-47s and put the lives of primary school kids in danger. These are the people who want to go out on bail, who still have a rifle that is illegal circulating somewhere. So, Your Worship, in the state's view, Section 60, subsection 4, paragraph A has been met, Your Worship. There's a likelihood that if released on bail, there's actually more than likely they will endanger the public, Your Worship, especially given the fact that they've got that boldness. So accused number 1 is prominent relatively. Knowing that people are taking video camera, video footage of what he was doing, his antics there, he still nevertheless went ahead. I mean, he was so brazen. So if a person is so confident and audacious enough to commit a Schedule 5 in public, what more a Schedule 1 in private? I mean, you might as well just committed it anytime. So, Your Worship, in the state's view, these are dangerous people. They will endanger the safety of the public. Releasing them on bail will prejudice the interest of justice, Your Worship. It's not in the interest of justice that accused 1, 2, and 3 be released. Now, as having given the facts, Your Worship, I move on to Section 4. Your Worship, just to state not only the facts, but factors and considerations which emerged after accused persons have been arrested. The first one being that for purposes of bail, they had to give their residential addresses to the investigating officer so that that can be verified, so that should they be granted bail, they can be easily pinned down to a particular place, and the court can, or rather the state can, know where they are should they not come to court. They can just go there and arrest them. So these are considerations which emerged after they were arrested. And 1, 2, and 3 provided details pertaining to their addresses and where they reside. And 1 and 3 said they reside Kumete Street somewhere in Albamani. And they gave that information to the investigating officer saying, we reside Kumete Street, there's a name, there's a number, it's given, your ship, it's on record, your ship, as I was reading the affidavit. There's a house number given, the street name and the area, Albamani. The police went there to go verify the address, only to find that that place doesn't exist. Doesn't exist whatsoever. And actually, that place is a complex. Well, Albamani, that suburb, where it's indicated, it's a suburb. As they went there, the security guards, before even going inside, the security guards told the investigating officer, listen, there is no Kumete Street here. I've been working here for some time, there's no Kumete Street. However, the investigating officer still said, you know what, let me go there and check for myself. Drive around, using scarce state resources to drive around looking for a street that does not exist. Only to find that indeed that street doesn't exist. And so we still currently don't know where accused 1 and 3 reside. Accused 1 has a tendency of he's been before courts on criminal or in relation to criminal matters several times. The affidavit indicates that it's about 9 times where there's been cases opened against him and such matters have been withdrawn. However, and furthermore, in those 9 times, he's given 9 different addresses. And now his son vouches for him, or accused number 3, in a way vouches for him and says, no, actually I'll also live where my father lives, at a non-existing address. So, we don't know where accused 1 and 2 lives, accused 1 and 3 lives. Accused 2 initially said, I live in Boksburg, Marbleton, Boksburg. When the investigating officers went there, yes, there is a place like that, Marbleton. There is a house number that's in line with what he gave the investigating officer. The neighbor confirmed, he wasn't there, the neighbor confirmed that yes, indeed, such a person resides here alone, which is also a bit of a concern. If the person lives alone, it might be a little bit too easy for him to just locate and be untraceable. However, now in his affidavit, I note that when he gave where he resides, he gave a different place now where he resides. Instead of saying I reside at Marbleton as being the place where you had gone as a state to confirm as being my residential address. Now he comes and says, no, I reside at number 3 Garfen Avenue, extension 2, Albamani 1401, at the place of my employer. The same employer which we do not know where he lives, who's got several addresses, and last week Friday, I don't know why the foresight of giving another address. On the same day, he gave another address, gave the court another address. So he's been giving several addresses in his track record. Now accused number 2 says, no, I reside with this person who's giving several addresses. So now coming to section 4, or section 60 subsection 4 paragraph B which indicates that it would not be in the interest of justice for accused person to be released if, or rather where there is a likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial. Now, a proper interpretation of section 60 subsection 4 paragraph A is given by way of having regard to considerations which are enlisted or listed under section 60 subsection 6 of the Criminal Procedure Act. No one really knows where he lives. Short to say, but then let me not say it. The extent to which the accused can forfeit the amount of bail. Your Worship, the state submits that accused number 1 is a man of means. As it is known, he's a prominent pastor. He can afford to forfeit the amount of bail which this court can give. The question whether extradition of the accused should be readily effected. Your Worship, when it comes to extradition issues, Your Worship, it's quite an issue, and furthermore, Your Worship, the nature and the gravity of the charge on which the accused is to be tried, the strength of the case against the accused, and the incentive that the accused may have to evade his trial. Now, when it comes to the gravity of the offense, Your Worship, that is borne out by the fact that unskilled to carry wartime weapons, accused person goes to a primary school and exposes children to danger. That's the gravity of the offense that the accused person is facing. Apart from all the other offenses, there's assault, there's kidnapping, which is also a very serious offense. And the state will show, in fact, that firstly, we're not bound to be proven beyond a reasonable doubt that there is kidnapping, but there is evidence, Your Worship, indicating that there is actual kidnapping. The applicant, or rather accused number 3, brought in an application with the children's court in this building for custody of the kids, and he gave the address where the kids reside being the grandmother's address, and the court understood that those kids should be residing there at that address. The accused number 3 knows very well that those kids, the court has made a temporary order that they should be residing where they are until pending the finalization of the custody dispute. He knows very well he was not supposed to take those kids. He took those kids against the court order. Now he comes in and he says his lawyer goes on and on about having the right to have custody over the kids. The issue of custody is still an issue before the courts, and those kids were placed at a particular place, and he knows very well where those kids are, and he went against the court and took those kids forcefully. So the custody, or trespassing, or what you call it, what's the other charge? Kidnapping charge. There's evidence. But moving, I was just sidetracking there. Coming to the law, the gravity of the offense. Your Worship, it's obvious, Your Worship. It stands to reason that these are serious charges. The strength of the case, the evidence is out there for everyone to interpret. The state has video footage. There's as the state was reading out the affidavit opposing bail by the investigating officer, he gave descriptions to several witnesses who are willing to testify before this court and tell this court during trial what transpired on the day. There's video footage, there's eyewitnesses. several eyewitnesses. Now the state has a strong case, has a pretty much open shut case. So that would give accused 1, 2, and 3 an incentive, Your Worship, a very strong incentive to evade trial. I mean, they themselves, it's not a speculation. You know, sometimes when people attend court or for trial purposes and their trial start, they speculating as to what evidence the state has. You know, some of them think, you know what, maybe they don't have that much evidence. In this instance, Your Worship, everyone knows, everyone who has a phone, everyone who has social media knows the state's case. And apart from that, in addition to the state's case as it is known in public, there's additional video footage the state has showing further criminal conduct, clearly indicating that there's sufficient, strong evidence against 1, 2, and 3. So much so that they may be motivated by the threat of a likely term of imprisonment to evade their trial, Your Worship. Therefore, Your Worship, the state submits that Section 60, subsection 4, paragraph B of the Criminal Procedure Act is applicable to the facts of this case and all the considerations which have emerged thereafter to indicate that should accused 1, 2, and 3 be released on bail, there is a likelihood that they may evade their impending trial, because no one really knows where they stay. The strength of the state's case is enormous, Your Worship, virtually insurmountable. It's not in the interest of justice for them to be released. Moving on to Section 60, subsection 4, paragraph C, which reads, where there is the likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Now, Your Worship, in accused 1, 2, and 3's affidavit, the accused person indicated that, indulgence, Your Worship, I will not interfere with state witnesses as I am not aware of the identity and or details. I am not in possession of evidentiary material or evidential material. Now the state submits that this is not true. This is a willful attempt to mislead this court by the accused persons. Because firstly, at least 2 of the state witnesses, Your Worship, as indicated in the affidavit, at least 2 are related to the minor kids involved in this issue, as the grandmother of the minor kids and the aunt of the minor kids. And furthermore, accused 1 and 3 are also related to these minor kids from the paternal as well. Maternally and paternally, there's a relation to these minor kids. Now, for accused persons and furthermore, in relation to the assault and the intimidation charge, these witnesses that were listed in the investigating officer's affidavit, they are complainants, Your Worship, in relation to 2 charges at least. They are actual complainants regarding the intimidation charge and regarding the assault charge. For accused number 1 and 3 specific, especially, to say we don't know who the witnesses are, it's a fabrication, Your Worship, and it's willful, Your Worship. They are not telling the truth. They are misleading this court. They know very well who the witnesses are, and they know where they reside. So, as to the evidence, as stated, there were 2 rifles. What has been confiscated from accused persons is 1 rifle. There's video footage of another rifle, which is unlicensed. This other rifle is evidence in relation to the possession or without the proper appellation, forgive me, Worship, unlicensed firearm, possession of unlicensed firearm. That's evidence for that count, and other counts. There's evidence, and that evidence is still in the possession, not physically, but accused 1, 2, and 3 know where that evidence is. They can, if they were released on bail today, they know where to go and conceal or destroy that evidence. So it would not be in the interest of justice for accused 1, 2, and 3 to be released, and they do not seem to be people who are willing to assist the state in the investigation of this matter, because they have not provided any information as regards to the whereabouts of that firearm or rifle. So releasing accused 1, 2, and 3 on bail, in view of the fact that they know the witnesses, they know them personally, they have a relationship. In fact, Your Worship, Section 40 subsection, or rather Section 60 subsection 7 indicates that in giving a proper interpretation of 64D, or rather 64C, some of the factors to take into account: whether the witnesses have already made statements, the relationship of the accused with the various witnesses, and the extent to which they could be influenced or intimidated. There is a relationship, Your Worship. Although the accused number 3 was not married to the family relation or rather was not married to his girlfriend or the deceased girlfriend, the state submits there is a relationship between accused 1 and 2 to the 2 witnesses stated in the affidavit, Your Worship. So, Your Worship, the state submits that Section 60, subsection 4, paragraph C, Your Worship, vitiate against this court granting accused persons bail, as that would be not in the interest of justice, Your Worship. And now moving on to Section 60, subsection 4, paragraph D, which reads, where there is the likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives of the proper function of the criminal justice system, including the bail system. Your Worship, interpreting this provision, Your Worship, the Criminal Procedure Act enjoins us to go to Section 60, subsection 8, and to consider certain factors, Your Worship, thereunder, amongst which include the fact that the accused, knowing it to be false, supplied false information at the time of his or her arrest or during bail proceedings. Okay, that's one of the considerations to be taken into account when interpreting Section 4, or Section 60, subsection 4, paragraph D. Now, and as an indication, or rather, as to whether release on bail will undermine or jeopardize the objectives of the proper function of the criminal justice system, or including the bail system. Now, Your Worship, the state has already mentioned that accused 1 and 3 gave false statements before to the investigating officer as to where they live. They pretty much concealed their residences to the complaint, to the investigating officer. So they gave false information, knowing it to be false. The state submits, knowing it to be false. For you can't give an incorrect residential area when you know that place does not even. You can't give a residential area that you know does not exist. Every one of us, if anyone asks me quickly where you live, I'll give them directly where I live. I will not think twice. I will not speculate or come up with false places and areas where I live. Accused 1 and 3, just in fact, what transpired, the investigating officer saw that what accused 1 and 3 did, they took street from the church and combined it with Albemarle. The church is in Katlehong, Albemarle is in Alberton. Combine the two together and say, okay, we live Albemarle, Gumede Street. Gumede Street is in Katlehong, Albemarle is in Alberton. Combine the two, created a false place and say this is where we live. There's no why they misled the investigating officer. No one knows. It's for them to know. And furthermore, they misled this court. They say we don't know the witnesses. We don't know who are the witnesses. But I've just indicated that they know very well who, at least 2 of the witnesses. They misled the court there too. So these are people, Your Worship, who are prone to misleading. Well, not the court, but then they misled. They gave some misleading information in the process of this bail application. So these are people, Your Worship, who are prone to giving false information. How can they be trusted should they be released on bail that they will actually abide by the conditions and come to court on every time the court is postponed to another date? They are dishonest. They are dishonest people. How can they be trusted? State submits they cannot be trusted, and therefore bail should not be granted. Furthermore, moving on to indulgence. Paragraph E of section 60, section 60 subsection 4, where in exceptional circumstances there is the likelihood that the release of the accused will disturb the public order or undermine the public peace or security. Well, Your Worship, the state submits that release of accused persons will lead to public disorder, Your Worship, in that there's already evidence, Your Worship, indicating that immediately after the events of the 5th of August 2024, accused number 1's property, being his church, was burned to the ground by an angry mob, angry members of the community, particularly at the school, in and around the said school. Now, it's evidence enough. It's not a speculation as to whether it will happen or not. There's evidence that it has happened before, Your Worship. And furthermore, Your Worship, they endangered minor kids who have parents, Your Worship. Those parents, Your Worship, are not pleased with, these are allegations, of course, Your Worship. But then these allegations are strongly corroborated and solidified by video footage that circulates, that they were at a primary school with wartime weapons. Parents of those kids I don't think they're happy with the situation as it unfolded on the said day. Given the fact that already there is this misconception in society, and furthermore distrust of the judicial process and so forth, Your Worship, by society, and now comes accused person, accused persons coming out on bail after they have threatened their kids at school, place where it is understood ought to be one of the safest places, because it is it should be a protected place. They went there with guns. As parents, I don't think they'll be happy if accused persons were to be released out on bail, Your Worship. And furthermore, in line, Your Worship, with that, I just want to read an extract from a Constitutional Court decision, Your Worship. This is S. Dlamini, the proper citation being a second edition, 1999, or rather 1999, volume number 2 of the South African Criminal Records, page 51, in comma, 1999, 4th edition, South African Law Report, page 623, Criminal or rather Constitutional Court, CC, where it is stated that, I quote, there is a widespread misunderstanding regarding the purpose and effect of bail. Manifestly, much must still be done to instill in the community a proper understanding of the presumption of innocence and the qualified right to freedom pending the trial under section 35, subsection 1, paragraph F of the Constitution. However, the ugly fact remains, however, that public peace and security are at times endangered by the release of persons charged with offences that incite public outrage. This is the Constitutional Court acknowledging that releasing some people, some accused persons, if they were to be released out in the streets on bail, there'll be a public outcry, and that would incite public outrage to a point where what already transpired may transpire again, because Your Worship, in all likelihood, accused number 1 will still go back to his. I hear that his church has been restructured, new marquee or new tent. Accused person will go back into the very same societal community wherein he threatened kids. He threatened their livelihood, their well-being. He threatened them with AK-47. He'll be going back there, further inciting the community members therein to act, because they see here is this person who's done this and now he's out on bail. So therefore, Your Worship, the system submits that from paragraph A to E, there is a ground or another which has been established. This is paragraph A to E of the Criminal Procedure Act, section 60, subsection 4, paragraph A to E. The onus is upon the defense or the applicants. I heard my colleague saying the state has not alleged that any of these grounds have been. It's not upon us to allege. They're supposed to prove or disprove the likelihood of any of these grounds. Not one. They must disprove that not even one of them, not even one will materialize. Now, I have shown this court that there is a likelihood that all of them might materialize, Your Worship. And therefore, Your Worship, given that into account, Your Worship, and taking that into account by the court, the state is of the view that accused 1, 2, and 3 bail ought to be bail application ought to be denied, Your Worship, and they ought to be kept in custody pending the finalization of their criminal case. And indulgence, Your Worship. Yes, Your Worship, those are the state submissions. Your Worship. Please open.
Thank you. I see the time is 1 o'clock. Advocate, let me know, would you want to have a right of reply?
Yes, Your Worship.
Are you going to be long, or should I adjourn for lunch and then come back?
Let's adjourn for lunch.
Be back, Mr. Wilagazi?
Yes.
Be back at 1:45.
So,
Not 2 o'clock. Need to move. It's already in the afternoon now.
yes.
The court then will take an adjournment for lunch. Back at 13:45. Mr. Wilagazi, you have the affidavits, correct?
Your Worship?
Exhibits. Can I have the exhibits? You took the exhibits.
Oh, yes.
All of them. Investigating officer, no, we only have one.
Well, here's another one.
We need 2 for applicant number 2 and 3. Then 2? You don't have applicant 2.
Bishop?
No, applicant 1. Affidavit.
Oh, here's one.
Thank you. Alright, court adjourns for lunch.